I want to share with you, and it's a reason that I'm passionate about the subject. If I can get this to move over. This is my father, Alex Silverman. In 1995, my dad, who was a lawyer in El Paso, came to visit. It was October 6, 1995. You remember certain dates in history. He flew in wearing his suit and tie, which he always traveled with, and because it was still kind of warm, a straw hat. And he still carried files. He was an attorney. He'd been practicing law over 60 years. And he stayed at my sister's home in Tempe. And the next morning I went to pick him up. He had a custom that he wanted to go to Coco's for breakfast whenever he visited here. I guess they didn't have Coco's in El Paso. And he complained that he had been short of breath that night. So I said, Dad, let's just go to the emergency room and, let's get it checked out. I'm sure it's nothing. So I took him over to Tempe St. Luke's Hospital, and they said after some testing that he was in congestive heart failure and that his lungs were full of fluid, and that the best thing to do would be to try to get him home so he could see his own family doctors. And he did have quite a team of doctors back home. His first cousin is a physician who had been his family doctor for years. So the goal was to get him home, so the next morning we were going to put him back on the airplane. And that night, my sister called and said, it's not going well, he's going to have to go back to the hospital. Well, before we knew it, he was on a ventilator, he was in dialysis. His wrists were tied to the bed post because he wanted to pull the ventilator out, and he was sedated, so he couldn't talk. And he was that way for about 18 days. For 18 days, we struggled to figure out what's going on. We never could talk to a doctor because the doctors always did their rounds at 4 in the morning, and we would always get there at more, sane hours. So there was never anybody to ask questions of. I finally called a friend of mine who was an internal medicine doctor, and he made some phone calls to be able to, interpret what was happening. And he told me that he is in very late congestive heart failure, and it's likely that if they remove the ventilator, he's going to pass away. So at least, we finally had some information that we could act on. And so my family, my sisters and I made the decision that this isn't the way our dad wanted to live. So we went ahead and we were all around the bed, and they took the ventilator out, and within a matter of minutes he was deceased. So while it was one of the saddest moments of my life, it was also, one of those moments, sort of a, aha moment as an attorney, because I counsel people on making these kind of choices, and here I was just completely, unable to make a choice, didn't get good information. My dad never really put this kind of information out there, what he would have wanted. So, I come here tonight with that background, and it's something that I'm passionate about, and it's something that I think everybody should consider so that your end-of-life wishes are known. And then there's another story that just came out today, which I thought was kind of timely. Did anybody see this in this morning's paper? Those of us who still read the paper.
It was online too, if anybody.
If it was online, about an injured hunter who fell from a tree, fractured his, I guess we'll call it his neck for lack of a better word, and his family was told that he'd be paralyzed from the neck down. And so the family chose to bring him out of sedation and allow him to make the decision of whether he wanted to live under that scenario. And he said no. And so he made it very clear to his family and his physicians. And they pulled the ventilator, and he passed away within about 5 hours. He spent the last 5 hours with his family, communicating. He wasn't sedated, and so that was his choice. So that's what we're here to talk about tonight. So we're not going to talk about the law so much as we're going to talk about where the law allows us to make these kinds of decisions. And so finally, Keith, would you mind coming up here, please? So what I'm really excited about tonight is that although we're going to be doing a presentation, what we really wanted to talk about are medical issues that affect us. And I've asked a friend of mine, Dr. Keith Power, Dr. McDreamy we're going to call him. Because we're hoping that we get a few more internet people logging on. And so with Dr. McDreamy with us, we might get a couple others. So
Sadly, this is.
we're hoping. We're hoping. So everybody back home, call your neighbors and say, Dr. McDreamy's on. Keith is an emergency room physician at St. Joe's Hospital and has had that position for 12 years. He's a partner in Empower Physicians. His education is the New York Medical College, the Emergency Medicine Residency Program, the University of Texas Southwestern Medical School, and the University of Texas at Austin. My father went to law school, by the way. So we're really thrilled to have Keith with us because I'm hoping that a lot of your questions, Crystal and I are going to dodge, and we're going to ask Keith because we're thinking that a lot of people, like I have a story, a lot of you have a story that you could either want to share with us or just get some help with these subject matters. So with that intro in mind, Crystal is going to start us rolling. Again, we have a little bit of an agenda here, but we're really very, very willing to get off agenda because we want to get Keith the opportunity to do more talking. He wants to be incognito. That's an inside joke, right? I think a lot of people know that name right now. Okay.
All right, so again, thank you for coming this evening. We're going to start out with a little quiz. The number of Americans who have expressed in writing about how they wish to be cared for in the end of life. 75%, 50%, between 15 and 25, or 1? 15 actually between 15 to 25.
Oh, it is?
It is. But still, that's not enough. With things that happen these days, Lou and I both feel that we especially want to encourage our clients and their loved ones to make sure they get the wishes in writing. A DNR and a living will are the same thing. No. That is correct. It is false. Dr. Power, do you see that people get those things confused a lot at the hospital, or?
Absolutely. Most of the time, what I do see is a DNR, as opposed to most people. Less people seem to have living wills when they do DNR.
Okay. All right. We'll talk a little bit more about the differences between those and what you might want to have and what you might not, or whatever. Here, when we get a little bit further into the presentation. The percentage of Americans surveyed by the Archives of Family Medicine who would not want CPR, mechanical ventilation, artificial nutrition, or hydration if they displayed severe dementia. 38, 53, 78%, or 96%.
38.
78%. All right. The reason that most Americans have not addressed end-of-life decision in writing is the topic is painful, emotional, it's difficult, or all of the above. All of the above. It is a very hard thing to think about and to talk about, and then to actually sign a document that really expresses those wishes. It's a very difficult
And
thing.
in here, I thought it was that they just didn't have good attorneys to talk to.
Sometimes that's the case, you know? The reason to have healthcare directives in writing is to ensure your wishes are followed, assist your loved ones in making painful decisions with your clear input, assist your healthcare professionals in counseling your loved ones to make the appropriate end-of-life decisions, or all of the above. All of the above. Absolutely. So every individual has the legal right to make their own decision regarding health care. So the article about the injured hunter actually talks about that, where you don't see that situation very often where they're able to bring someone back and that person have the mental capability to make that decision at that time. That person did, but because they wanted to try, he was able to make his own decision. The government has interest in medical decisions, including preservation of life, safeguarding the integrity of medical profession, preventing suicide, and protecting innocent third parties. If someone becomes unable to understand or reason, they still have that constitutional right to make their own medical decision, even though they have these issues. especially when we're talking about end-of-life care. That is the constitutional right that they cannot take away. We'll talk a little while about mental health care powers of attorney, and Lou and I both use those in our practices, and many of you probably have those documents in place as well. And here we're most definitely talking about these end-of-life decisions that we can't take away. Individuals can appoint a healthcare representative to make these decisions, which I hope every single one of you here have that. And if no individual has been named, the law itself, the state of Arizona has a statute that says who gets to make those decisions on your behalf. So some people wonder what that will be, and we'll talk about that as we get going. Lou, I think you're up.
Okay, thank you. So before I move to what are advanced directives, I'd like to ask Dr. Power a question. Would you mind coming up, just because people in McDreamy land won't be able to see you? So the scenario that I described, where as a family member, I wasn't able to get any good information while I see a loved one just failing, what would your suggestion be as to how we would handle that situation, and how do we get good quality information?
Well, I mean, I think that's a matter of just the timing. It was the 1960s as well, and people were rotating earlier, but now.
It was 1995.
95?
Yeah, it was still a while ago, though.
Okay, all right. Currently, I mean, when in our hospital, it seems that we would have physicians and a lot of people.
Speak up a little bit.
Yeah.
Absolutely. So at our hospital, it seems that we would have, it's surprising to me that there wasn't enough people to really answer those questions and give you a better decision, a better idea of what the condition is and what's the likelihood of that person returning to normal function. I mean, that's really, as the years have gone in the last 2 decades, we've definitely tried to make some moves as far as understanding the end-of-life issues and speaking better with families with regards to that. Because as a healthcare profession, we have definitely failed over the years of doing so. Really, technically, I mean, it shouldn't be your lawyers talking to you about doing DNRs and healthcare advanced directives. It should be your primary care doctors. They should be addressing those earlier. And once you get to the hospital, you should have there are now palliative care teams. There are a lot of different people that will sit down with you, tell you what the situation is, and tell you where you stand as far as the likelihood of returning to normal activities of daily life. So.
Stanley?
Do they have hospitalists now in every hospital? Because they're there 24 hours now.
I wish they were there 24 hours. Not all of them are there 24 hours, actually, but yes, we do.
I thought they took a shift.
So
Let me just repeat the question.
Absolutely.
The question is, do they have 24-hour on-duty hospitalists now? I think was your question, right? Okay, thanks.
So intensive care units definitely have physicians on 24 hours a day. It's kind of like the emergency department, it's around the clock. Hospitalists, in my particular facility, we have 3 groups of sort of hospitalists. One's the teach service, so there's always someone there with regards to that. They actually have someone there. But we have 2 other private hospitalist groups, and in fact, they're there quite a few hours. They're during all normal business hours. But in the middle of the night, there's a good chance that they're not there, actually. So there's a good 5-hour span that they might not be there. But those hospitalists are taking care of, obviously, not the critical care ones. So if your loved one is in the ICU, there should be someone that's willing to speak to you at that time. It's a little harder because there's going to be one individual, as opposed to during the day, you have the full team and complement of ICU doctors there that are seeing their regular patients, and then the one that kind of covers everybody during the night.
If in fact you do have poor communication going on, who should you focus your question to at the hospital so you get a response?
That question was, if you're not getting good communication, who should you focus your question to at the hospital?
So it gets relayed down to the appropriate person and you get a response.
Kind of hoping you were going to take that somehow.
No. I'm the lawyer.
Well, I mean, I would hope, actually, probably the best patient advocates in the hospital are not the physicians, but the nurses. And I would probably ask the nurse the next person, who can I speak to, because I do not feel like I'm getting the answers I want. I mean, we all know that a lot of physicians are not necessarily the easiest people to talk to and don't always have the best bedside manner. But nurses really are there. I mean, they go into that profession because they are the best patient advocates. And so I would talk to them and try to figure out who is the next person I would talk to. If you are in a critical position, you probably have multiple physicians too. And hopefully one of them will be able to answer questions a little bit better for you and able to sit down and give you a direct answer. It's you know, I know it's just like you guys have a difficult time discussing with your family ones about end-of-life issues. Physicians don't really like to say, you know, it's hard for them too to sit down with someone and tell their loved ones that, you know, this is unlikely they're going to come out. And we, you know, in the United States, we've just failed upon that, you know, doing that, being able to sit down, being taught as physicians how to really sit down with families and talk to them and let them know that this is, you know, we're not really doing any good with the treatments that we're doing now, and all we're doing is really prolonging potentially death in some cases.
Thank you.
So Keith, on the healthcare directive, if you just want to come over here for a second, but I'm not going to let you sit down. So again, really briefly, because I think most people here know what a healthcare power of attorney is. I think most people in here have one. So it's a way that you can, you know, have an agent speak for you and hopefully put into writing what your end-of-life wishes are. And this is where I think there's a failure on our end as lawyers and probably on your end as our clients in really putting into writing what your end-of-life wishes are. We say, I don't want my life prolonged if I'm in a terminal condition. But what does that mean? I mean, what does a terminal condition mean in terms of end-of-life decisions? I know people that have cancer and they have it for 20 years, so obviously they're not in an end-of-life scenario, but many are. So, and this gentleman, the hunter who I read the story about, do you recommend that we think that through and put into writing, if I have that kind of an accident, I don't want my life prolonged, or I do want my life prolonged? Could you talk about that for us?
Absolutely. I mean, there's quite a few things you want to address when you're thinking about, I mean, so commonly I get a simple DNR form, and it basically says, in the event that it's unlikely that I will, in the event that I've reached a terminal condition or I'm in critical condition and unlikely return to a reasonable form of life, then I do not want cardiopulmonary, I don't want the chest compressions, I don't want the tube down my throat. And they just list the major things. But it's one little blurb, and people sign it, and they might say that, but it's such a gray area. So it's very difficult for us as physicians as well to interpret, well, what do they really mean by this? What is important to them? What do they think is a meaningful part of life? And my interpretation of what I would want is going to be totally different than the next person. So I do really recommend addressing each, try to address some of the major issues. It's impossible to go through all the scenarios. You'll always be confronted with something new, but if you sit down with your spouse and your family, or have a nice drink and just kind of discuss through things and just run through some scenarios. Hey, I wouldn't particularly want to live if I'm going to be on a ventilator and have a tube down in my throat and I can't speak and I can't get out of bed. Then those kind of things are nice to be addressed. Some people would. If they still have mental capacity, they might want to be alive. Others might not. So there's a few things. First you want to address, do I want chest compressions? And we can talk about that a little later after we get through some of this, but the CPR, how well it actually works, and what conditions it works. It really is, it's not all that successful, and we often just bring people's heart beating again, and really they're going to be in much worse condition than they were than they were before. Very rarely are we going to actually bring them back to a good, meaningful life. Now, there are circumstances, definitely it works, and it works great, but there's so many other times that we do it that we just know that it's the long-term result is not going to be good. So you want to address that. You want to address whether or not we want the tube down, whether or not you want IV and fluids and hydration, whether or not you want nutrition. So at what point do I say I do want the tube, where they're going to feed me through a gastric tube, and it's unlikely I will get off of that gastric tube. I will always be on a gastric tube. Is that something you would want to do? Other things you might want to address is dialysis. Your condition is so bad that do you want to be on dialysis? Do you want to continue to be on dialysis? A lot of times dialysis can be, a lot of these things can be short-lived. You might be on dialysis a day or two, and then you're off, and you're not going to be going to dialysis for the rest of your life. So some of these things you want to address, okay, I wouldn't mind being, you know, I'm okay with them doing dialysis for short-term, but if it's something that's going to be long-term, this is not something I would want for my quality of life. But each and every one of those you should kind of discuss through, and you know, it helps your family and it helps the physicians talk to the family if we have something a little bit more in detail with regards to what you want, as opposed to, I just don't want chest compressions. So.
Any questions as a follow-up to that? Yes?
Yeah, how about a pacemaker? Now, does that keep a person alive? Like, my mom had a stroke, and it was so massive that they said, and she wanted to, you know, she had her wishes known to her. But she had a pacemaker, and so it took a long time. Now, would that be something you have to specifically say? They would not turn it off. And I wondered how that affected her end of life.
There's going to be some difficult
I think,
questions here.
you know, my feeling is that if you have a pacemaker, you would want to specifically say, I want it turned off.
It seems like that would be a good idea.
Yeah, absolutely.
No, but would a pacemaker by itself extend life if all other life support was eliminated? Could it, I guess?
It would support life for
It
a while,
would,
yes.
it would,
If
okay.
it's truly a pacemaker, as opposed to something that's a defibrillator or, if it's a pacemaker, yes, I would believe that. I mean, obviously, if you have a lot of other condition, a pacemaker's not gonna extend life and.
Right, not indefinitely, obviously.
Right, in a septic, you know, a
But to
person
make
that's
it go on.
overwhelming infection, kidney failure, there's so many other
Right.
things, respiratory failure, that pacemaker's not gonna do much. But let's say that if you are just having, you know, a specific brain injury or something along those lines, yes, that pacemaker could extend life a little bit more.
And, you know, that they would not turn it off seemed ridiculous to me. You know, we weren't extending her life, we were letting her go, and yet they said, no, we can't do that. And I'm thinking, what, she's going to die? I mean, you know,
Right.
it seemed ridiculous, but because it wasn't specified, she just said no interventions, you know,
No,
what do they call it? Extraordinary
Right,
interventions.
probably that basic.
I thought that was
form of-
pretty extraordinary, but they
Well, it
didn't
could be-
agree with me.
Is it pretty invasive to turn one off? Do they have to go into
No.
surgery to have that
No.
turned off?
No.
Okay. I-
No, it can be turned off outside.
She could have done it herself.
With a battery.
She was not conscious. And I didn't know how.
All right, put your hands up.
I don't know.
So before I let you go, and then we'll move ahead, if get a patient in the ER, which is a lot of times where people with real critical injuries end up, not so much maybe critical illnesses, but injuries like the Hunter we talked about. At what point, as the physician, do you believe it's time to have that conversation with family that talks about some of the end-of-life issues? What questions do you ask them so that you can educate yourself about your patient?
Well, in the emergency department, first and foremost, I mean, we try to support life. And, you know, most of the time, in an otherwise healthy individual, even if this individual had a do not resuscitate or a living will, or had all that in play, we wouldn't know that when he arrived in the emergency department. So we're going to absolutely do everything we can to support life. And in those cases, you know, I wouldn't even really begin that discussion yet, because we would have to really do a further assessment to figure out where we are on the potential of quality of life afterwards. Is he truly going to be paralyzed for the rest of his life, or is there a potential of having some sort of recovery in his neurologic injury? So in that specific case, you know, we would do everything, and I don't think I would begin that conversation. But a head injury that we know that is so bad that they're debilitated, and the neurosurgeon's already come down and said this is absolutely what it's going to be. He's going to have no brain function, but he could potentially live in a vegetative state forever. We would definitely have that conversation, and that would be with me or and the neurosurgeon together, and the intensivist, and try to sit down with them. Most of the time, the neurosurgeon does that conversation with them to say, this is such a devastating injury that they will never have permanent function afterwards. In which case, you hope they have some power of attorney or living will, and she can go that direction.
I often, my clients will say, well, if I have a living will, does this mean if I'm in a car accident, they're not gonna try to save me?
Right, no, absolutely, just like I say, that's always a big fear, that if I have a living will, that it means do not treat. That's not the case. DNR is not do not treat. We definitely treat, and in fact, we go to the other extreme, that we treat everything. You know, I mean, the terminal patient that clearly it was their time to go, they don't have anything on paper, then often we are doing very invasive procedures that most of us would probably deem very inappropriate. But we continue to do it because we don't know their particular desires, and this is just the way the state of America's healthcare system is. We prolong life as long as we can.
Right.
Larry,
And
you had a-
and at the same time, there's a lot of fear, like, oh, are they gonna hasten my death so that we can harvest organs?
I get that a lot when I ask people if they wish to be an organ donor.
Right.
I'd say a third say, well, I'm afraid that they'll, just want my body and my organs too fast.
Yeah, I've definitely heard that. No, and again, we fail as a healthcare profession in really harvesting the organs that we should have done in the first place. That's the last thing on our list most of the time. So, no, I've never seen anything under that circumstance at all.
Or that you.
And we in fact have to keep people alive so that we can harvest those organs. So we actually do everything on the person that is terminally ill or has the brain injury. We will do whatever we can with all kinds of medications to keep them alive for a short period of time, and so that we can harvest the organs, and then we allow them to pass.
Larry, did you have a question?
Are we basically talking about people who don't have any healthcare directives now? Like, I have a healthcare directive, okay? And in that healthcare directive, it pretty well spells out what it is. Are we talking about people who don't have it, or are we talking about one way or the other? I mean,
It's difficult. I kind of thought about that as a scenario too. So you perfectly healthy, walking around, talking, have a healthcare directive. So if you came in and had an event, God forbid you have an event, and you went into the emergency department, I'm going to still treat you to the fullest extent because you were perfectly fine before. It's not like you have a terminal illness and you're bedridden already, in which case, right. So I'm going to treat you as well as I can, and then we'll try to sit back and say, well, this is, and then you come, and that most of the time I'm not even going to know your healthcare directive because you're coming in the emergency department. It's not like you carry it around.
Many of our clients do, actually.
Do they really?
Yes.
There was an
We have
emergency
document.
physician that actually it wasn't a friend of mine, but actually tattooed DMR.
I'm carrying my DocuBank with me.
Yeah. Many of our clients are enrolled in DocuBank.
DocuBank.
DocuBank will store your healthcare directives electronically. There's a card that they carry with a member number and a PIN ID, and the healthcare directives can be accessed from anywhere 24/7.
So in an emergency situation, though, I'm not gonna take time to say I'm gonna stop and then go try to look up on a DocuBank. I'm gonna do it again, and then once we stabilize the patient, then we make that decision. And yes, we do withdraw care sometimes. So we find out afterwards that I've intubated a person and they have a DNR, then we will sometimes withdraw care, but try to contact the family and say this is true, this is what his wishes. Are everybody okay with that? And then we usually will withdraw the supportive care at that time.
And to your question, Larry, we're talking, about healthcare directives in general. Even for folks that do have healthcare directives, most of the living wills and healthcare power of attorneys that we have and share in our offices with you all are still fairly basic. I ask all my clients if they want to add some personalizations to those, and I always encourage that, because you don't know what could happen. And just as Dr. Power said, there's a lot of scenarios out there that we haven't thought through. So we get, in my office, and I believe Lou's office has started doing this as well, a letter of instruction to our healthcare agents that you can include other scenarios, other things that you might not have thought about. And we highly encourage folks to do that and have those conversations. So the personalization is good for everybody, whether or not you have a directive. But otherwise, it's still questions for folks that don't have one. So,
If you can stabilize me to the point where my family is there and I can talk, but yet my end of life is near, wouldn't that, I would still be in control of my end of life at that particular time. Is that correct?
Absolutely.
Yes.
Okay.
That's
So-
why they brought this Hunter out of sedation, so that he could make that decision.
So I could discuss that with my family there at that particular time, regardless of what I had written on there.
Absolutely.
It's really, these papers are just to assist your family and the physicians in making decisions on it. So to get an idea of your wishes. But you can, just last week, I had a terminally cancer patient that pretty much bedridden. The family had decided to put her in a hospice care, had a DNR form filled out, but as she was in the hospice, her condition started to decline. They got scared. They came to the emergency department and they rescinded her DNR. So we did whatever we could to keep her alive, even though she was terminally ill with metastatic cancer. So it's absolutely, in that case, it was the family's decision. And it doesn't matter. Everything we always ask, do you still want to continue with these advanced directives? We should always ask.
Thank you.
Been through a couple of bouts of elder care with both mother and mother-in-law. And with the caregivers in their homes, we were suggested, and I thought it was a good idea, to put their living will and their directives on the refrigerator in the kitchen. Because that way, she was not getting out a whole lot, but that way, if paramedics were called, then it was boom, boom, they knew exactly where it was and it went with them, and the caregivers knew it, and it made it much easier to communicate.
The DNR, the true pre-hospital medical directive, must be printed on orange paper, and they do suggest that you put that on your refrigerator. And so it alerts the EMTs or whoever, if you do have an actual DNR, you should take precaution. You can print it on an orange card to carry it in your wallet. So it is a separate thing from a regular living will. And it goes much further.
Why don't you
than
go
just
in,
that.
this is a good time, Krista, why don't you explain the difference
Okay.
between a living will and a DNR? Because a lot of my clients get the two
Yeah,
confused.
absolutely. So the living will itself is just the written statement that expresses what you would want if you are in the terminal condition, a persistent vegetative state, or an irreversible coma. And Dr. Power, I'm sure, would tell you that those are going to be determined by the physicians. They're going to look, they're going to do the research, they're going to talk with the family, they're going to figure out, do they have a chance of coming back and having those activities of daily living and other things. But you have the ability to express these wishes. And it doesn't allow healthcare providers to stop tube feedings. Only the agent or court-appointed guardian can do that. But this is the document that can contain specific personalized instructions for what you would want in those situations. So this is just more of a general one. Everybody, in my opinion, should have a living will. Even if that person does want to be kept alive as long as possible without regard to what's going on. Because as we talked about in the quiz, with so many people of the mindset now that they don't want to be, they want that quality of life. I think that's very specific to each of us. What does that quality of life mean? But the living will really is more basic in that sense. It's just everybody should have it because we don't know when our time is going to come. That's the way that I think of the living will itself. A DNR is really, it's, in my opinion, a little bit extreme, but when you are ready and in those situations, it might be appropriate. So, they're really appropriate for people who would probably not do well with CPR. Dr. Power was talking about, we could talk a little bit further about what CPR is and how it actually helps or not. Other life-saving measures because they're very sick, they are terminally ill, or they're otherwise extremely weak. Like, it is truly the end, or very, very close to the end. The decision to use that DNR is very personal and should be discussed with your doctor or treating physician. I don't do DNRs in my office. I don't believe Lou does them in yours
Well,
either.
we
Occasionally.
do, but I try to convince the client that, if you have a DNR and you faint and you say you have a mild heart attack, and if the emergency personnel see a DNR, they're gonna leave you alone. And that means that you may not recover from what could have been a mild heart attack.
Right.
Or, like the Houston Texans coach who had a mild stroke on the field. A DNR technically would mean, don't treat him, isn't that right, Dr. Power? Don't treat him because he has a DNR?
What is a DNR? What
Do not resuscitate.
Do not resuscitate is what it's kind of known
Yeah,
as, but it's a
so-
pre-medical or pre-hospital medical directive here in Arizona.
And the mistake that I see people making is they think a DNR is a living will, so they say, I want a DNR, and I try to explain what a DNR is as opposed to a living will. And so the DNR is an absolute, don't touch me. Is that correct? Or if you see a patient come in and they have a DNR on them, what do you do in a situation like that?
Well,
And I know you said you don't, go through their wallet to look, but let's say that
for some reason they didn't.
the emergency people bring them in and say, here's the DNR, we found it posted on the refrigerator. What do you do at a time like that?
And they're incapacitated and can't speak?
Yep, that's right. Yeah, Gary Kubak just came into your hospital and from the football field, and he had a DNR on his person. What are you gonna do with him? He had a mild stroke. What do they call that? What do they call that? Yeah, TIA?
TIA.
He had it on national TV. I'm surprised he didn't see it. It was in the football game the other. He was working.
He was too busy treating
What happened was,
patients.
he's the coach of the Houston Texans. He was walking off the field at halftime, and he collapsed, and we heard more about his physical and medical condition during that game.
Probably a lot of HIPAA
Probably
violations.
you
Privacy
did.
Act.
Yeah, a lot of HIPAA laws were violated. But the point is, they say he had a mild stroke is what they called it. So they rushed him to the hospital, and I'm sure he's doing fine now. But what if he had had a DNR? And everybody knew he had a DNR. It was tattooed on his helmet or something.
Do you have an example of a DNR, actually the specific wording or anything? Because it,
No, didn't bring it.
but again, it has to be, so it has to be an event. We're talking about a DNR, doesn't necessarily mean do not treat. So if he has a mild stroke, I'm still gonna treat his mild stroke. It doesn't matter if he has a DNR or not. It's really whether or not we're talking, do we want cardiopulmonary resuscitation?
Right,
Or cardiac meds. Do I want to start if his heart stops beating?
Right.
Or he stops breathing, do I want to start chest compressions, and do I want to put a tube down?
And that'd be the resuscitation part of a DNR.
Yes.
So there you would,
So resuscitation is a specific word. It doesn't mean don't treat. We're going to treat for strokes. We're going to treat, if a person comes in even with a hemorrhagic or blood stroke, so the bleeding in their head, they're still, the DNR doesn't really come into play too much yet, unless they stop breathing, in which case, do I put a tube down them because they're not breathing?
So-
And quite frankly, if you are not breathing because you had a huge bleed in your head, then the likelihood is the condition's not going to be very good later on. Let's just be careful when you say that I don't want to do DNR, it does not mean do not treat. Okay.
I think though, in Arizona, this pre-hospital medical directive under the statute, it goes a little bit further than that. It's not just DNR, it is, I believe, a do not treat. And if the EMTs see that posted, that orange paper posted on the fridge and they do something,
But what
they're
does treatment
liable.
mean?
They're not supposed to touch you. They're supposed to.
Oh, boy, I don't do that.
But a resuscitation is a different wording.
But it's not actually a DNR. It goes further. It's a pre-hospital medical directive. It says, I
It's
don't.
not a DNR, it's a
It- I mean,
personal.
exactly.
But isn't a DNR usually related to a specific condition?
Not
not
always.
necessarily,
No.
no.
It
No.
can be.
That just seems dangerous to have a
It
blanket.
is. I believe it's dangerous, and I don't think you want a DNR unless you are absolutely at the point where you're ready to check out, This is Hotel California, and you're checking out.
Because I just had the
Because,
bleed in April, aneurysm, and they, I wouldn't have wanted that.
Right, so they did.
Because I was out completely.
you wouldn't have wanted that, meaning you would not have wanted a DNR.
Yeah, because
Well,
I don't
you're
know.
with us
He had to-
tonight.
They had to call
Right.
Ralph here in
Right, you're with
Arizona.
us
I was in
tonight.
St. Louis.
Yeah. Right. So I think this is where we get some confusion in the law and in the choices about what these mean.
Is there a difference between a no code and a DNR?
No code?
The question is there
No,
a
I-
difference between a no code and a DNR?
I think what they're trying to say on the no code is is that we do not want to do CPR and intubations. So no chest compressions, no cardiac meds, and do not intubate the patient in the event would be a no code. And now she's got me wondering about the DNR as far as.
Yeah, because
Arizona.
yeah, the statute for the, so always, maybe in another state, you know, always think about that. Every state is a little bit different in their laws and what they call things as well. So in Arizona, what we call a DNR under is really a little bit different under the statute, a pre-hospital medical directive. And with that, it must be signed by the principal and a healthcare professional. It must be on letter or wallet-sized orange background paper. And it really is, if the EMTs come to your house and they see that, they're not supposed to use anything to start your heart or
Right,
breathing.
and that's what Keith is saying, is that we're talking about if your heart has stopped or you're not breathing, DNR would mean don't assist. But you're saying in many situations,
The patient's.
you are breathing and your heart is beating, but
Right.
and
Most
you need
situations,
help.
yes.
Right. I think that's the distinction you're
Right.
making.
If you have a stroke, you're still breathing
Yeah.
and your heart's still beating.
Right, this is.
And if your heart stopped with your stroke, then yes, they would not initiate resuscitative efforts, cardiopulmonary
Generally speaking, and I know this is a hard question, asked so broadly, how long before the brain has reversible damage when you stop breathing?
Ooh,
Just,
You know,
I
that's-
know that's a hard question,
Yeah,
and
it's-
there must be a lot of different, but
I
just
think
generally, you know, you just, well, not if you're in ice cold water, but I mean in normal house temperature.
So it's.
You walk in, you find your significant other on the floor, and you've been off at the computer with your headset on, you know, you don't know. You know, it was half hour, it was 15 minutes, it was, how long before we don't want to make that phone call to the paramedic, knowing they're end of life, they don't want to come back?
I think we'd always make that, if there's, you mean there are, they were otherwise, otherwise walking and talking and fairly healthy, and then you're saying you found a person that's been down. It really depends on a lot of other comorbid illness. So if they have terminal cancer, the likelihood of doing well after that, after a full resuscitation is very little. But if you're a 50-year-old man or a 60-year-old man that just drops down from sudden cardiac death, then I would say full resuscitative efforts all the way through. Now we do cooling of the patient, and we've had some really good efforts when they don't have a lot of other conditions going on. If they turn out that they had huge pneumonia and CHF and their kidneys have failed, then that really makes it much more difficult. So, and unless they've been down for a very long time where they're just pale, their eyes are open, and it's an otherwise I would make the call.
How about with stroke?
Well, there's two kinds of stroke. There's the ischemic stroke where you're not getting blood to the area and there's bleeding in the head. And I personally, I'm at Barrows in St. Joe's, and I always personally fully resuscitate and let the neurologist and neurosurgeon, because sometimes they'll come down and say, we can do something, we can take them in and see what we can do, and they might return to a fairly decent quality of life. And then in other cases, the neurosurgeons say this is just they're not even operable. We can't even operate on them, in which case we can withdraw care. But again, in the emergency setting, let's get them stabilized first, and then we'll decide those things afterwards. So yes, and with ischemic stroke, if right off the bat, we want you to call 911, get to the hospital, and we can potentially give you medications to help unblock that stroke, the clot that caused that stroke. So yeah, with stroke, I would say call 2. I mean, I pretty much believe, unless you've already established that it's a terminal illness and the stroke might take your life, well, let's maybe not go to the hospital because I didn't want to be resuscitated anyways. I'm ready to go ahead and pass. That's what he's saying. That he recommends to his clients that let's not do the DNR until we know that we're ready to go.
So just to clarify, because EJ was so sweet to pull this up for us, so the pre-hospital, I don't know if you have a larger over there, I can read it here, but it says, if you have this form, EMTs and other emergency personnel are not to use equipment, drugs, or devices to restart your heart or breathing. but they will not withhold medical interventions that are necessary to provide comfort care or to alleviate pain. And it must be on the warranty paper to be valid. So that's a true living,
So-
or a true do not DNR in Arizona.
So, and you can see how there's still an ambiguous situation, ambiguities in there. What does that mean? So I will not, I would not put a tube down it. That's the one that's very clear. I will not put a tube down a person's throat to help them breathe. I will not start chest compressions on this patient. And there are certain cardiac meds that I wouldn't give. That pretty much is what it means to me. Everything else is, I can still treat. I can give IV fluids. I can give pain medications, medication relief. I can give antibiotics. It starts to get a little questionable once you start to use things like TPA, which is the clot-busting medications for. So there's all gray areas, and that's why it's so vague. And this is why we like the living will, to really have more advanced. And even then, with those, it just helps us discuss with the family, discuss with the other physicians, let's try to make a best decision possible as a team. It's all can be withdrawn, doesn't have to happen. It's just something that we all need to think about before, and hopefully it'll help make the family make these decisions a lot better and easier.
I think we had one more question before you
So
sit
the
down.
living will is a good start for everything.
Yes.
The DNR is for, I want to say, when you're older and you already know you're aged and things might happen and you don't want to live. So DNR would be later. It wouldn't be for somebody in their 50s, like you said. You wouldn't want somebody to come and not do something to you, get the DNR and you're 55 years old or whatever. You don't want that. So it is for somebody who's older and has the terminal illnesses, or they're just aged and they would not want to live. Do you have a sheet also for all these other things, like, that we were talking about, these other scenarios, like, just a list of, the gastric tube, the dialysis, the mobile, do you have a list, like, of things like that, so people can check off and sign, or no?
The one that we've been giving out doesn't have those. I have one like that, and I used to give it out to clients, and no one ever filled it out. So I stopped giving it to them, but I think we should.
Actually, when I did the estate plan for Keith and his wife, Keith is really the one who pointed out to me how short and sort of insufficient our living will was. And so I think you had kind of done your own based on your kind
I
of
did, and
knowledge
now
and-
that we're having this lecture, I'm starting to
You're
think
gonna
about
do
more.
some more.
I want a copy of yours.
Everybody has different,
Yeah.
the emergency physicians, we definitely don't want things done. It's weird, most of us. And I think I
It's like when you know how sausage is made, you don't want to eat sausage. Same thing. But we're now starting to give our clients, in addition to the 3-page sort of standard living will, a 10-page instruction document that has a lot more what-ifs on it. And it probably doesn't have enough, but I mean, at what point is, too much? Because people are just not going to fill out a book.
That's what happened with the
But
other.
but that's what we're
But
doing,
if you
though.
have that, do we carry it around with us? I mean, like, if
No.
something happens to him, he's in a car accident or whatever, and then I've got the papers at home, I mean, how does that?
You share it and communicate with your loved ones.
That's the most important
Oh, so I can
thing.
just go down there and say,
The
hey.
paper is really what I want you to do is.
Take the paper with you.
Oh.
Just- It's really just discuss with your loved ones, so that the person that's the power of attorney or whoever is, I think they'll go over who would be the next in line with regards to makes decisions. We'll have a good idea of what your wishes were. That's the most important part.
So we can we don't have to have the paper, really, we can just.
If you're the power of attorney, you don't really have to have a paper, no. It's helpful, because then it helps the
Well,
physician know that this is what the
But,
patient
I mean,
really
like, I
wanted to
wanna
do.
know what
I don't know,
we
actually, it might be more of a legal
Well,
question.
it's a legal question in that the facility needs to know who your agent is and that
Yes.
agent has the capacity to
So we
speak
do
for
have to
you.
have that.
The
We
power
have-
of-
Eventually, but I mean, I tell my clients, make sure that these documents are accessible. So you may not have it with you, but if this happened to Keith, you're gonna go home, you're gonna get what you need, take it back to the hospital. Because in the short term, they're assessing anyway. So it's not like you're gonna make that decision usually immediately.
So if we're out of state or somewhere and something happens, it's best to have this DocuServe or whatever it is? Okay.
Or we copy a lot of these documents on a flash drive and you can just carry the flash drive with you when you travel, so you have it available with you.
Oh,
Yeah.
yeah.
It was a legal question, actually, for you guys.
You're not permitted to ask
Well, I'm not.
You can
Sorry, the doctor's asking a question.
Well,
Go ahead.
Just from a general, just as a general comment, but it appeared to me that we ought to take the do not resuscitate thing and throw it to the four winds. You know, it's no good. You know, we all pretty much agree with that thing here tonight. I think that nobody likes it. You know, so how would I use it? I don't know. The answer is I wouldn't ever use it, okay? And I think that about everybody in here would agree with that. So why do we even have it? That's what I'm wondering. And why do we even offer it? Only because the state says we gotta do it is the reason we're doing it.
Well, we don't have to do a DNR. You don't have to have that. That's an additional thing that you
That's
can
what I'm
do.
saying.
Right, absolutely. You don't have to have one of those. And that's why we don't typically do that as
But-
part of our practice.
It
But
seems
your
like a
point,
big- it seems
but I think
like-
your point is, if you have one, nobody's gonna honor it anyway because it's subject to so many
Yeah,
interpretations.
that
That's what
could
I'm
be.
hearing.
You're very much true.
Yeah.
I think that's true, yeah.
It's again, you know, I mean, if you have a DNR, it might very well be that no one knows about it. I don't know if I have, I might even in fact have a DNR myself.
I did not do a DNR.
I wouldn't mind having one actually on file. It's not like they're gonna know unless my, you know, in the event that something comes around, it makes it a little easier. But I guess the advanced directives would answer that question.
Well, yeah, it would. I mean, what's it doing? To me, it just gets in the way of everything else. When you think about it, think logically about it.
So if you're, and then again, it's, if you're in a terminal condition, then you're basically saying, stop, don't take me, don't do all these things. I did not even want to be resuscitated.
It's already in your other living will. It's already, you've got your directives already. You've already got your directives, so why would you want that?
Well, I think the point with the pre-hot, the DNR on the orange card is that you can put it and it stands out. So if you were just to be carrying around your healthcare power of attorney or your living will itself, people may not understand or realize what those are. But if a healthcare professional, an EMT, finds you and finds the orange card, there are certain things they'll do and certain things they won't. So it's a little bit different.
You know, it actually might be you're right. I think that's why I said earlier, maybe I see DNRs much more frequently than I see living wills. Is because at that point, the person may be already incapacitated, so they discuss with the family, they're in a nursing home, and then a DNR is signed at that point because they can't really go through a full living will and get every little specific detail down. But they can say, okay, in the event now that I'm incapacitated in a nursing home, the family does not want this patient to have full resuscitative efforts. So that's why I do see that much more frequently.
What are the negative consequences of full resuscitative efforts to the patient?
The question is, what are the negative consequences of full resuscitative
You're making it
efforts?
sound very,
Invasive and not pretty.
yeah, well, and just not desirable.
Well, I mean, it depends, you know, the sudden cardiac death, it is very desirable. That is a person that has a good chance of recovery if caught early. So the person, this is why we have the AEDs, the defibrillators in the airports and in certain locations, because if you can restart a heart right after it happens, then we can cool the patient and there's a good chance that they'll have some sort of quality of life afterwards. Some people have walked right out, 40-year-olds that, you know, especially the younger, healthier one that doesn't have a lot of other medical problems, walk right out 2-3 days later after being dead for a period of time.
So that's the positive side, but what's the negative? So if somebody's older and weaker, is it gonna make their quality of life worse should they recover?
It's not, I mean, you can definitely do damage with resuscitation. I mean, we are doing very significant compressions and pressure on the chest. We crack ribs, we crack sternums. This is how hard we go. With regards to intubation, if you put a tube down on a person that's terminally ill and unlikely to get off the tube, then you could be very well that person that lives in the hospital for 30 days intubated. Like your father, I guess, was in the hospital for 18 days
Right.
with a tube.
With a tube.
And so really you're just prolonging something that the patient would not have wanted in the first place. It's really, why we have that, why we don't want to do it is really, we don't want to go against the patient's wishes or the family's desires and wishes. So we want to make sure that
So you had a question, it's your turn. Didn't you say you had a
I
legal
did.
question?
I did.
This is the one time I don't charge.
I'll have to get back to you on that.
Okay, all right. So,
Yeah.
we've talked a lot about, you know, if you have these directives, and now everybody's gonna go home and have pages and pages of them. But what if you don't? And this is kind of where the opposite side of the coin would be, you have no directives, and you've appointed nobody. So by state law, there is a role that's called a surrogate decision maker. So there are certain persons that will automatically qualify to be your agent, even if it's not who you chose. Spouse, I think is probably on the next slide, Crystal, but spouse would be, well, there you go. So spouse, or your children, or your parent, or your domestic partner, or your brother or sister, or your close friend.
But it goes in this order. So if these,
Yeah,
the people on the
right.
top aren't the people you want,
Yeah.
you definitely need a directive.
And so, first of all, if you don't have anything, even though your spouse or your child or any of these people can make those decisions for you, they have no roadmap, because they have no idea what you would want. So when they're having that discussion with Dr. Power, you know, it's like, well, this is what I think, but I don't know, so this is why it's so important to put it in writing. But the other problem would be that a surrogate decision maker cannot withdraw hydration or food. That's kind of a weird quirk in our law, that only a healthcare agent appointed in writing can do that. So I don't know if you really get into that distinction in the hospital setting, but by law that is a distinction.
Not in the nurse department, no. So-
Okay, so that really isn't something that you deal with in the ER. But that is important to know, that if you don't have anything in writing, it doesn't mean you won't have an agent, but you won't have an agent who really knows what you're doing, and they won't be able to withdraw food or water, which does in many cases keep people alive when they wouldn't want to be. So, Don?
If you have all this in place and you're incapacitated, so you have an agent that you've named, and you have a DNR, like in the case where the woman was in hospice, he said the family rescinded it. So she obviously directed, and if sound mind said she didn't want, she wanted the DNR, but then the agent rescinds it, which is counter to what. Yeah. So the agent can do opposite of your wishes, right?
Well, I think that,
They have the ability?
personally, I don't think an agent has a right to rescind your DNR. I think if they did that, I think that's inappropriate.
Well, actually, so to clarify that, it was actually the agent that established the DNR for the patient in the first place, that rescinded the DNR in this
Well, she
particular
didn't
case.
do it, or
Yeah,
agent.
she did not do it.
Okay.
Although, again, it comes back to, it's really a discussion with the family, because I'm gonna wanna know, you know, you don't wanna rescind a DNR if the patient really wants it, but it might be the scenario where they come in and this is a completely reversible condition, in which case that is an appropriate time to rescind that DNR, say, let's hold off, we're gonna go ahead and treat it, because we will get them back to where they were before this present illness. And so it's still a gray area on whether, you know, but I think we err on the side of keeping an individual alive.
But your agent can counter what you say, or in your living will and stuff?
Well, I think that it's because of the gray area. You may say in your living will or in any supplement to your living will that you don't want your life prolonged, or, you know, you get real specific, but it's still your agent who's ultimately calling that shot. And it's your agent who has the legal authority to speak for you. And so, you know, that's just a scenario that the agent does have to ultimately make that call. And it may not be the call you would have made.
I think from a practical perspective, I always tell folks no offense to our doctor friend here, Dr. Power, but I think that from a practical perspective, if a physician were to follow your living will without looking at your, you know, for the final decision from your healthcare agent, if they they can't actually withdraw the support on their own, but if they were to do that and you pass away, you're not coming back to sue them. right?
Right.
So it's gonna be your agent who didn't want that support removed that is gonna sue that physician or that hospital. And so they're going to err on the side of caution. They wanna make sure that they're doing everything they can for the patient, because we are a very litigious society, and it's very sad that it kind of takes away some of the things that we would wanna be able to make those decisions for ourselves. But from a practical perspective, they're always going to look to the agent to make that final decision.
And so that's kind of the next subject briefly would be the immunity. So, go back, there we go. So there's always a question in our society about being sued. And so statutes provide a certain amount of immunity. So the person who makes the medical decision as an agent is immune from being sued. And then the next slide should tell us that the providers are also immune. So, can you go to that one?
Yeah, so we talked briefly earlier about how directives can be revoked. So if there's somebody that you don't want to be your agent, you obviously need to tell them, have that written document in place, but you can revoke healthcare directives in writing, orally, by notifying a surrogate agent or your healthcare provider, making a new healthcare directive, or any other act that demonstrates a specific intent. So if you did have a living will or a DNR and you decided that you didn't want that anymore, you can revoke it that way. And then you should also try to collect and destroy copies of all outdated or, documents, things that have been overridden by your wishes or don't meet your wishes anymore for those things. So some places you might have them, you might not think about. What if you've given them to your primary care physician? What if you put them on file with a local hospital? Some people do that. The Arizona Secretary of State has a free healthcare registry. Many people use that and upload their documents there. DocuBank's another place. If you've given them out to your agents or other folks, so that you try to collect them and let them know that that is no longer your wishes and you have new documents.
I'm not familiar with DocuBank.
DocuBank.
Bank, oh, okay.
Yeah. Do you offer that through the client?
We haven't done that before.
Okay, so DocuBank is there's other ones out there, but DocuBank will send you a wallet-sized card to keep in your wallet that has access via the internet or fax 24/7 to your healthcare directives. You can store healthcare powers, mental health care powers, the living wills. They also have other options to store medication lists and other things like that. So that if you are out and you have an event, clearly you're probably not going to be carrying around your healthcare directives. But if you have the DocuBank card in your wallet, it comes with some stickers you can put on your insurance card or your driver's license that says, I have healthcare directives. Because if you are in a car accident or something else, one of the first things they'll do is try to look for your insurance card, right? Sure. They want to make sure you have some insurance. And so when they do that, they'll find that, and then, like Dr. Power said, they may not go immediately and get those, especially if there's a really emergent situation, but they ought to be able to, and they do have access to those documents.
So the responsibilities of the healthcare provider, and we've talked about this a lot, and I think now we've confirmed that there's a lot of gray area, that the healthcare provider will comply with your decisions, and yet your agent is speaking for you, so there's going to be some gray area, but you want as much as possible to put those directions in writing. And then what happens when the healthcare provider does something that may not be popular? So removes treatment, doesn't resuscitate, takes a person off life support, and then they get sued. Well, the statutes provide immunity for the healthcare provider in that situation if they're relying in good faith on a healthcare directive and the agent's directive. They're immune from liability. It doesn't make them immune for negligence in carrying out their medical responsibilities, just in doing what the agent instructs them to do. Is that much of an issue in the hospital setting? Is that something that's discussed behind closed doors about the concern about lawsuits in these situations?
No, I don't think so. I mean, I think we generally, it's in an emergency setting. I'm usually doing the best I can with regards to, most of the time I don't have the advanced directives unless they're coming from a nursing facility or somewhere where they come with all their paperwork. So we usually just follow the direction of what their advanced directives are. When you were talking about it, it was interesting, I was thinking about your DNR and your advanced directives. And if I have both, I skip the DNR and I go to the advanced directives. It has the detail of everything they want. It's going to say in there, don't do chest compressions, don't do cardiac meds, don't do intubation. Transfer me to the hospital, don't transfer me to the hospital. And like they said earlier, it's very important to do positives and negatives. Yes, I do want intubation, but I don't want this. So with regards to the legal issues, I think we often err on doing what we can for the patient, probably a little bit more, and a little less worried about being sued if you're doing treatment for the patient, probably. Although I did read about one case where there was a patient that was DNR, they were uninformed of that particular case that they were DNR, but everything was done for that patient after a cardiac event. The patient actually walked out of the hospital and was doing quite well. 2 months later had a stroke, and then there was a lawsuit saying if that person had not revived during that initial event, then we would have never had the stroke and lived 2 years being debilitated.
Who would take that case?
I don't know.
The personal injury attorneys out there, not us.
Crystal, you didn't take that case.
Did not.
Yes.
How about if you're older people and you travel overseas, how does all this fit in when you're out of the country?
The question is about if you're traveling. So we do recommend, again, if you travel, at least within the United States, it's a good idea to carry that, your flash drive, which was what we're giving clients now. So all of your documents are scanned, and you can take that with you, and you'll have it when you travel. If you travel for an extended period of time in particular, so that you could actually, take that with you, and that could be, plugged in right at the hospital, and they could read. It's another question if you're traveling out of the country.
So you're in India or Spain or,
I think it would be the same. It would be a little bit more difficult, but it'd be the same scenario. We would try to we would do what we can for the patient. So if you're traveling in India, they're probably not going to know your advanced directives. We would do what we can to resuscitate the patient, make sure to stabilize them, and then start to explore, can we contact family members? Do they have advanced directives? Is there something more at that point? Whether you're in India or you're in the United States, it's just a phone call. We can get those things over the phone as well, and faxes and emails and DocuBanks, frankly. We can even do that.
Do we have those flash drives?
You should, yeah.
We do?
You should have gotten one. You were just in the other day, so you have to.
It's notebook. It's clipped in my notebook.
It's inside your red binder.
I didn't know.
It's clipped inside the red binder.
I put it in your binder so you don't lose it.
Yeah, you have my red, yes, you have my binder.
Before we take your question, do you mind if we go ahead and we've got a question
We have a
online
question
here?
online. David Burns is online. His question is the advice the same for the guardian of a special needs adult? Are similar documents suggested?
So the question is for the guardian of an incapacitated adult, whether these documents are advisable. And the answer would be absolutely yes. If the individual is incapacitated by law, they've lost the legal ability, so they essentially have the same capacity as a minor. So the guardian would be able to execute those documents and make those advanced care directives, and you would honor those, and just as you would from the individual themselves.
And in fact, anybody 18 years or older should have them, and it also should have a HIPAA release as well, because to be able to make those decisions, your agents need to be able to have access to your healthcare records. So it's very important that if you have grandkids or other folks that are going off to college and they're going to be on their own and they're technically an adult now, they need to have some directives, and the parents need to have an ability to make those decisions on their behalf without having to go through the awful living probate process to get guardianship and conservatorship and all
And
those
in
things.
answer to that question too, if you already are appointed as the legal guardian for an adult incapacitated person, you have the power to make medical care decisions by law, even if there is nothing in writing. That comes with the territory of a guardianship. So you could cover that in a couple of ways. Put it in writing, but then the law gives that capacity to you anyway. I had a case a couple of years ago where a gentleman had had a stroke and didn't have a living will, and therefore, and didn't have a healthcare power, and his family wanted to withdraw hydration and water. You know, they didn't want him tube fed. And because they were the surrogate and didn't have it in writing, they had to go to court in order to become the guardian so that they could make that withdrawal. Because the guardian has that power, but the surrogate does not. So sometimes we do go to court even in those situations.
So you can be a parent of a disabled child,
Yes.
and unless it's in writing, as that you're also the guardian, you don't have say on that kid?
Well, if you have an incapacitated adult child, that child needs a legal guardian. So most of the time, you're going to find that the court has already appointed a guardian. Because that person needs to make medical care decisions, insurance decisions, housing, all the things that a minor would require.
But what if they're
an
mentally up and down, sometimes
Well-
able, sometimes not?
Well, I would say that again, and that, that person should have these documents in writing, powers of attorney, living wills. When they're up and they're lucid, they should create these documents. So if you as a parent, then you would have that power. And again, if they're incapacitated, then they would need to have a guardian who can make those decisions for them.
One thing, since we work a lot in the cruise industry and are out of the country a great deal, and we see lots and lots of medical emergencies. One thing that people frequently will take health insurance, and even Medicare and so forth will stabilize you in the country until you can get home. So your medical expenses frequently for people are covered, but what is not covered is your evacuation from a large cruise ship. On average, that runs $170,000. I'm told, of people in that insurance. So, if you're cruising abroad and you're in tenuous health, or just to be sure, it's usually very cheap if you're just taking the evacuation insurance. But we do it ourselves when we travel.
Well, I do know that they offer that travel insurance when you take any, extended vacation where there's, higher risk.
And that has lots more involved
Yeah,
with it.
lot
But
of-
the
lot of
evacuation
coverage.
part
Yeah.
of it is very inexpensive
Right.
if you don't use the rest.
That's right. And it's a good value, okay, for what it covers, so.
How many people here tonight are just here to consider the living wills that haven't done them already with either of the lawyers? Has everybody already got one then, tonight? So what about our children as parents, like if we have grown children that are in their, late 20s, should we encourage them to do these living wills now, or can we as their parents, if they're single and they're adults, can still make the decisions for them? Like you said, we're on the list as the parents.
Well, you're the automatic surrogate by law if they're not married. But again, you couldn't withdraw food or water because the provider will not take that authority from you because you don't have it. Now, I'm not sure how important that is in the big picture, Dr. Power. How important is it that you'd have a patient who has everything else withdrawn but food and water in the big picture of things? Is that person going to live, quite a while in that scenario?
Longer, definitely much longer. I mean, I guess we could, and then you talk, I mean, we all remember, was it Maria?
Sherry
Sherry Shiloh.
Yeah, in Florida.
Right. And that was a scenario where she could live for decades.
Yeah.
And they wanted to withdraw food. So that was the food and the IV fluids was what kept her alive for so long.
So the answer is, it's really best that they have it in writing, they appoint you as the agent, and then you can make those decisions. And it allows you to have the discussion with them and get more detailed about, what they would want too. Because you don't always know what your child would want.
Are those something that we could do? Do we have to do them through you, or do they have the living wills that are like online and that type of thing?
Yeah, honestly, they're all over the place. I know the Secretary of State's website has living wills and healthcare powers of attorney. So yeah, they're available without a doubt.
I have two stories about the Terry Schiavo thing. I have a girlfriend who's a lawyer, and she requests that she would be just like Terry Schiavo. She would not want anything if she was pretty much totally gone, but kept alive. And so we had this disagreement about this, and so, you know, that's what she wants, and that's how she wants to be taken care of. We recently had a friend of ours who, talking about the food and the liquids and stuff, and he is in the hospital, and he is basically vegetative brain dead, 19-year-old boy, and the parents in the first 2 days did not want to make that decision to pull everything, because they were hopeful. And now it's been 4 weeks, and they want to pull it, but they've already traded him now, and he's breathing on his own, and he could live for a long time like this, because they waited for him to do it in the first 2 days. So
it's, but I wonder, can they, in this case, can they remove 2 feedings?
According to, in Arizona, food and water cannot be withdrawn by a surrogate.
So that'd be a
That-
surrogate.
That'd be a
The parent
surrogate.
is a surrogate because it's an adult, so it can't be
Yeah.
withdrawn. And in which case, I guess you'd have to. I mean,
You'd have to, when you
court.
go to court, get the guardianship appointment, and then you would have that power. So that's where you have to connect those dots.
And they have, you know, I mean, these scenarios do come up, and they're rare. I mean, we're talking about rare cases for most of us here. We're just, well, you mentioned that we asked everybody who doesn't have a living will, and pretty much everybody has a living will, but how many of them have discussed it with their families and their children too? Because it always becomes an issue when maybe the spouse is saying something, but then the family comes in, and there might be a child that totally disagrees with the spouse. So it really kind of needs to be a discussion amongst the family as well, so that everybody kind of gets an idea that, hey, when it's my turn, you know, my son knows that I do not want this. I don't want 2 feedings. I don't want intubation if I'm going to remain intubated. You know, these kind of things, so that he will understand that the wife, who is the power of attorney, will be making the decisions that's in my best interest, as opposed to, you know, someone might disagree with the mother, or whether or not it's even their mother, but it's a
Siblings disagree all the time.
siblings disagree all the time. Maybe it's not the biological mother that's making the decision, has power of attorney now. There's just a lot of things, so it's best to discuss it with the whole
we
family.
had one brother who disagreed about a DNR on a mother that was in a nursing home for 10 years. And one brother held up everybody for a
Right.
couple of years until he finally agreed. So, yeah.
We'll take one final question, or maybe 2, but then we're getting into tonight. So.
On guardianship, if you go to court, get the guardianship papers, then are you financially responsible for an adult child?
No, a guardian is only appointed, it's called guardian of the person, so you have legal power to make decisions for the person. Healthcare, you can insure them, you can educate them, you can house them, but that doesn't make you financially responsible for them.
You don't have to do those things.
No, you don't
just
have to.
try
That's a conservatorship is kind of the sister to a guardianship, and the conservator is responsible for the finances of an individual. In other words, what they own, what they receive, and the way
They
of
don't own
benefit.
anything.
So oftentimes you don't need the conservatorship.
I'm just wondering, we were talking about being specific about, you know, your wishes. Can you also be, are people ever specific about like what kind of comfort care they want if they are being, you know,
Absolutely. I
can-
mean, they usually have, a lot of times on those advanced directives and the specifics, they say, there'll be a question, I do not, or I do want pain meds. I mean, I don't know
Okay.
who would say I do not want pain meds, but it's there. And I would specify that, so that you're basically, it's a positive assertion, like, give me pain meds. Don't just hold them because you say do not DNR or there's an advanced directive. That doesn't mean, I want my pain meds. Make sure it happens. Make sure I'm very comfortable. Make sure that I'm not aware of any sort of pain or discomfort or anxiety that I might have, so.
because again, in my scenario with my mom, the thing of, that the doctors did not want to give the pain meds. They kept saying to me it could cause, you know, hasten her death.
Right.
And I said, but we've made the decision, she's made the decision. Why do we keep having this discussion about
Because it's very-
hastening?
Right, and it's weird. I think, you know, I don't know if I specified in my living well, but I remember discussing with my wife, it's like, I don't, just give me as much as you can possibly.
Yeah, and I kept saying,
And I just keep on going.
yeah.
But I do recall.
Most living wills do say, I do want to be provided with comfort care, which is, you know, pain relief.
Right, but it doesn't really, you can't really say in there, well, give me so much morphine that I'm not gonna be breathing anymore.
Right.
But, you know, it's interesting, my father passed in 2004, and I went back to Dallas to take care of him during that time, and it was at home, it was hospice care, and I just remember during that last week, he was pretty miserable. And to this day, I still regret, why didn't I give him a few more pills of Xanax and more morphine? And there was no point in not doing that. But it was still, once it becomes family, it becomes emotional. Even as a physician towards patients, it's still, you're actively giving something that might hasten their death, so you feel uncomfortable with that as a physician. So
Yeah, they were very aware of that all the time.
it's not the legal as much as you just start to feel, we're all taught, let's save people, you know?
Right.
And not quite taught as much in the United States, and they're getting a lot better, probably after the years I went to medical school, but palliative care and really whole teams that work together, like how do we make this person comfortable, because they've failed so much in the past. But it makes us uncomfortable to give us medications that will possibly cause them to stop breathing. You're actively doing something. But we obviously did that, and I did that in medical school all the way through the point now. Let's make sure that we give plenty of medications, we just don't call it that we're giving so much that it might make them comfortable and it might actually slow the bleeding to the point of the test.
How long can a living will last for? I mean, can it last like, is it 10 years, 20 years? Or do you want us to renew them like every so
Well,
many years?
There is no legal termination of them. We recommend, particularly for powers of attorney, that when you update your documents for any reason, that you update your powers of attorney. The reason is, number one, there may be some changes in the law or, you know, some of the verbiage that we've addressed. The other reason is that we find that third parties look at the date on these powers of attorney, and if they're older documents, they tend to kind of shy away and say they're not current. Well, they're current because they're your last document. But you get into the argument, well, they're just uncomfortable with them. So we just like to say, if you come in to see us for virtually anything, let's just update your powers of attorney at that time. Jason, do you have a comment on that?
We worked on a client together because their power of attorneys were beyond our three-year comfort level. Lou had to redo them, so we had to recertify them, even though they were still the exact same thing.
Right.
They'd gone enough periods where we as third party couldn't use them.
But see, by statute, there is no termination, but in practice, third parties just become uncomfortable with them, and you start, you know, it's like you can't fight City Hall. You argue with these third parties and what's still valid, but it's like, okay, let's just renew them when we can, and then we're in better shape for that.
Mostly we have the issue with financial powers of attorney not
Right.
being accepted. Healthcare powers and living wills typically are pretty good. Many financial institutions on those powers of attorney, 3 years. Some of them are now down to 6 months. Some of them, it must be their form.
Yeah.
But even some of the healthcare institutions are getting a little bit tighter on this. Mayo, for example, you must have a HIPAA that is their form.
Well, you bring up a point too,
So
because the HIPAA laws, which have been in effect, I don't know how many years now, but a decade or so. If you have an older healthcare power of attorney and it doesn't have the HIPAA consent, which is the healthcare privacy consent, then you absolutely need to update it, because without the HIPAA consent, the healthcare providers are not permitted to disclose information about a patient. So now with the HIPAA consent becomes an issue. So you always want to make sure that you have a good up-to-date HIPAA consent. So, all right, well, we're going to close out at just about 7. So don't go away. I want to thank you. I want to thank you for joining us tonight. Most of the time when we have a guest, I like to urge our participants to have an immediate need to visit with our guest. Tonight we'll pass on that. But I do appreciate your being here. If I'm ever in the emergency room, I would like to have somebody like you to be around.
Yes.
Thank you very much.
We have at the end of your packet there a review, and what we'd like to do is get feedback and to sort of bribe you to stick around for a few minutes and give us your feedback so we know what you want to hear about. Is we have 2 gift certificates for Nello's Pizza in Tempe, $50 to give away. So if you'll turn those in, we're going to draw one out blindly. In fact, can you stay around for a couple of minutes and draw? to offer pizza? Sure. And then we're done. I appreciate everybody coming tonight. Thank you.
Thank you.